about those dividends and those coupons a little bit easier than the debtor coming back and saying, hey, I need you to discharge this and send it to the principal. That's the part where I see non-adverse ways, and then I see the straight up go at them type of way, and I'm just more about just conversing with them just enough to get them to acknowledge, my rights. And then once they, acknowledge, yes, you're right, you're correct, and under laws, yes, you have the right to rescind, you have the right to do this, yes. So I have the right to correct this. All right. So please and thank you. I don't have any intention of not banking with you anymore or closing this account. So any threats or coercion or extortion will be held, in a more public platform. You understand? And I'm gonna put a price tag on that. Don't call my mom. Don't call my uncles. Don't call anybody's name that's on that document. Don't bother them. That's crazy. Don't they be asking y'all for information about somebody else? What's your mom's address? Like, what? Please. You know what I'm saying? Like, what my mama got to do with this? Mm-mm.
They want to call and harass people so you can go ahead and give them the money. That is extortion.
It is. And then we're not wording it right. We're not even stepping on, like, it's really like no need to cut and dry. Like, they are really, if they fail to perform, right, that is definitely something. And then they're going to threaten you,
Mm.
take shit, steal shit from you, and then security
Hmm.
fraud. Oh, hell no, y'all. We is not playing this year. Mm,
Right.
no way. No, but always, I got to know what you did first. Is there a power of attorney on file? Did you do it registered mail? Or did you do it certified mail? Like, once I get that, and and some of these affidavits, I don't know if you drafted your own. Like, some of them are not needed to be so long, 2 pages, 3 pages. Like, it's really not that. You just want to show evidence of this communication about this subject and their failure to comply or to, disclose whatever you're requesting. It's your account. You're the account holder. Shit. Send me that. I got counter deeds. Like, we got so much information in the mortgage section. Like, I can go over mortgage. There's so many different ways to go at this. Um, Request for transfer of mortgage assets. I'm writing the request to transfer of the following mortgage assets to my trust account. Right. So the mortgage on my property, that would go. um, Let me see. You can purchase your mortgage. There's something called a deed. I think it's a deed in lieu. I forget what.
Mm. I'm going back in there tonight.
Yeah, it's in the mortgage section. Like, I got, and this one sister, she sent me something, and it was like so informing on just a process that you can go through the courts to get this stuff. Wait, let me see if I can find it real quick.
I think a deed in lieu is quiet title.
Yeah, I don't know if it's releasing your whole interest in the property though. So we went over it. I just brought it up in the topic so we can discuss it. But I'm
But I
just
don't know. I'm not for sure that I'm gonna Google it.
yes, a deed in lieu, special or full endorsement, partial endorsements, conditional or qualified endorsements. Like, we show you how to do all this stuff in the group. Like, you don't need to ask nobody nothing. Like, it's there.
Mm.
Um, Let me see. Promissory note. I'm writing you as trustee of the blank trust regarding a promissory note dated on in the amount of. I kindly request your cooperation in providing the following information within 10 business days from the date of this letter. Confirmation of your status as the current holder of the promissory note. If you are not the current holder of the promissory note, please provide name and contact details of the current holder. Failure to respond within the stipulated 10 business days will be construed as acquiescence in accordance with the Uniform Commercial Code. Please be aware that any attempts of coercion, duress, or threats will be deemed unacceptable and may result in legal action.
Mm. Nice.
Listen, we got to get them, y'all. And I put together like so many different ways to come at them. And it says the Supreme Court ruled in Carpenter versus Longan, 83 U.S. 271, 1872, that a promissory note and a mortgage are inseparable and that the mortgage follows the note. This means that if a promissory note is assigned to a new owner, the mortgage is automatically assigned as well. The Supreme Court reasoned that the mortgage is simply an accessory to the debt that the promissory note represents and therefore cannot exist independently of the notes.
Mm.
We ain't playing. We ain't playing. We got this. You can request all. You take all of that information and compile your own affidavit. You're in there somewhere. And I got some
Carla
more.
Faye, that's the host that's speaking. So right there it says host box. Oh, well, you just click on Truth Hurts and go to his website on his profile.
going on, Goddess? Aisha, what happened to that lady that was doing that mortgage?
You know what, Ain't just why I came up here. I don't know. I haven't. I actually
Her-
sent her my number and text her, and she told me she's gonna call me back after the call. I haven't heard from her, so I hope everything worked out with her. But I don't know.
Man, I hope
What does
so.
she need?
Got it. She got that paper, man. That's all she needed. All she
Yeah,
Okay.
needed was that paper. She got it. Satisfaction of mortgage.
she had to record it. Yeah, she had to record it at the Secretary of State. This is like I've done everything I need to do, but I still got to record my documents. If you don't record it, what's the point of having it?
If it's private, why would you need to record it?
Well,
Separate.
the satisfactory or mortgage, I don't know what else to
Oh,
advise her to do because they were trying to, she had a foreclosure sale date, and I'm not at your level of expertise. So I just knew that she had a satisfactory or mortgage letter, and that's the document everybody want. And that's what we all pay our mortgage for. So I was like, just go record it.
That's evidence to her claim for her position. For her,
Hmm.
but that would be evidence to her claim in her case, as far as how you gonna foreclose on something that's satisfied. As
Right.
far as for what they're enforcing. You're enforcing because you're saying it's non-performance. Well, here you go, a completion of performance. So that's an
all right.
oxymoron, you know.
Those that already got their mortgages paid off, like there's like a whole, it's called it says uniform request and cancellation affidavit for mortgages and vendors liens. It says the promissory note has been paid, forgiven, or otherwise satisfied in full. Affiant requests that the clerk of the court, parish, whatever, cancel the mortgage or vendor's privilege recorded under mortgage vendor's privilege number.
That's what I need.
See?
That's the document I need because my promissory note says that I paid my lender with they dumb asses.
Ooh, where you? Are you in Telegram? What's your
You want me
handle?
to upload it?
Well, I can send it to you on Telegram. I can just send
Oh
it to you
yeah,
now.
I'm on Telegram. I thought you wanted to see what I was saying. Yeah, I'm on Telegram. Hold on. Let me
Send me a message real quick. I'll send it to you.
okay.
I think I'm gonna need that letter too, man.
I got you, brother. I
Me
got you,
too,
brother.
brother. Me too,
I
brother.
got you, man.
Hey,
Got
did
you.
you talk to Red, bro?
Yeah, I did, man. We had the good sister. I'm not talking about not nor downplaying y'all. Don't y'all come at me. I'm just saying I needed some confirmation. Like sis was telling us a whole lot, and I just wanted to clarify that we don't need to do a lot of that to do the things that was shown. So I'm gonna get with him tomorrow.
Okay,
You know,
fair enough.
yeah, definitely we need that. But he just agreed. It was the let me see if I can bring it up real quick. It was adequate assurance. Yeah, notice of adequate
Right.
assurance of performance and settlement.
Right. I mean,
Yeah.
overall, it was a good dialogue, though, right?
Oh yeah, for sure. Yeah.
Okay. Okay. All I care about, brother.
Hey, we gotta get it there. We gonna get it. Don't quit, y'all. Don't quit it. We right there at the cusp of this whole thing. I just want to see that one person's face when I just give them these instruments, in this form. Just the BC. I'm not talking about anything else. I
No
don't need
doubt.
no new contracts, but
Hey,
just that
slow and
BC.
steady wins the race, brother.
Right. I'm gonna just send it in for the college loans. I'm gonna send it right in. Like, here, there you go. Take this. And then any taxes too. They can get that too. Act of 1871.
You know how to endorse it, right?
Yeah, yep. Front
Yeah,
and
well,
back.
that's it. That's it.
That's it. I accept it. And they're gonna charge the same to the public account. I get it. I mean, like I said, I just needed somebody to validate it, and brother validated it. That's all I needed right there. Let's see, Asia got it here. Okay. Who was I just at? And who else? Donald. Give me 1 second. I gotta find it again.
Have you all read the 1,000?
What the hell? Excuse me, I hit the button.
That's a hell of a ringtone, bro.
No, that was something on Telegram, some old Christmas thing. Let me see. Forward this. Kev, was it Kev? Kev wanted it, I think. Or Kev, you just got it. I don't know if you meant you wanted that or not, but you got it anyways. Let me see. And Isha.
And this says for people
Asia. Is it Asia or Aisha?
that pay, right?
What was
It's,
that?
Look like Aisha.
mm.
And Donald too. Donald said, I want it. You got
Can
it.
you send it to me? I put my email in the chat.
Oh man, now you want me to perform extra.
I love me some
I don't
Columbus.
have your Telegram. That's why I didn't want to bother you for that on the.
That's it. And just
What
send
is
me
it?
a message.
Truthhurst.com?
Mm-hmm.
I don't want to leave the live yet, so hang on.
Gotcha. Yeah, Michelle, if you just message me, I'll send it to you. This is actually a court document. Like you can download this document from the courts. But what I did is I revised it. Like I just did my own version of them. But most, if you look at the title of it when you get it, just Google it in your county, and you'll see their version of it. You got a uniform request and cancellation affidavit for mortgages and vendors liens. And that's the same one. My fault. I meant to show you this other one.
But if I've done a UCC 11, I just need to attach that with this document and just saying that and show that they basically got the money up front.
Right. There's no debt. You got a certified UCC 11.
Yeah, they come certified.
Mm-hmm. Yep. Yeah. I know you can do a UCC 11 search, but they give you an option to get a certified version of it.
Yeah, I
I
paid for
took
the
I took
certified.
mine to the Secretary of State personally and got it done, and I'm recording it tomorrow at the county recorder.
Beautiful. And that's what you stand on. I want you guys to know that that's very
Yeah,
powerful. So
I'm taking on some more too.
yeah. Now with properties, we know that they have liens within the like mechanical lien section, I guess. Like they have liens somewhere in there. So when you're dealing with property, you being the surety is what we're addressing here. You're saying that I owe you something and there's nothing on file here. So that's another thing. Like you did your due diligence, you researched the all caps name, there was no liens attached to it. So I need you to validate this debt per blah blah blah. And a banana.
I asked these fools, I was like, if the promissory note is incorrect, just inform me so we can revise it. If the promissory note is correct, then state it. It's saying that I gave y'all the money. Which one is?
Right.
So they haven't answered yet. I'm just go ahead and do, like you say, do the default judgment. But I'm not gonna lie, I'm changing my warranty deed and going to take the UCC 11, and I've already converted it over to the trust. But I'm
It,
also supposed to do revise my warranty deed and record it.
here's the biggest fraud on their paperwork on your promissory note, and it's always usually number 2. It says the borrower's promised to pay, and it says, quote unquote, their wording, in return for a loan received from lender, borrower promises to pay the principal sum. Now that sentence alone right there was never a loan received because they took your money and deposited it. When it's called a banker's deposit, I think is the correct term, and then loaned you back your own money. So if your and mine says promissory note at the top of my page, and it literally says in return for a loan received from lender. There was never a loan received, ever.
But that's what gets me. Like they act like they loaned you the money. Like that is crazy. Like so
Because
don't
they
that
Took
just
your,
tick
yeah,
y'all
they
off?
took
Like
you
that
right.
they did not loan you that money? Like that's
They
crazy,
just took your
bro.
blank endorsement and cashed it in.
Yeah, it took went right to the Treasury Direct window and ka-ching. We're just gonna
and then after,
Ka-ching.
and don't you know why they told you didn't have to pay the mortgage for 45 days? Because they waited to securitize the mortgage, break the mortgage, and take that security and start trading it for the 30-year note on the Bloomberg Stock Exchange on the back. So a $200,000, $300,000, $400,000, $500,000 mortgage turns into probably $1 billion in a 30 years
Right.
time.
So they scooped theirs off the top.
Oh, continually, because they take it every quarter. And to pay out the investors is what I learned also. It's pretty incredible that they can get away with it as long as they have. That's why we definitely all got to stand up against this bullshit.
Yes, it.
But it's good that at least we woke up to it and we learned how to do it, and we're doing the processes. And again, you have to go through it, and the only way, even man said today, if you got to do it to know it. Just and not just taking templates. You got to customize stuff. Every situation's a little different. All the mortgage companies, but it's all pretty much the gist. They committed fraud and breach of contract. I mean, is the logistics of it.
Hmm.
You
I
just
want to
gotta
read this
tailor
for you
it to
guys
your
real quick. I
own
want you to see
situation.
what these insurance companies do. When it comes down to not finding this stuff. But check this out. This is their request to the courts, and it is called an affidavit of loss parafide, if I'm saying that right, parafed note or release instrument, and request for cancellation of mortgage or privilege and release. Right? So it says, this is what they say. There is no known or potential claim to be indebtedness or obligation secured by the lost paraffin note or release instrument. We request the cancellation of the mortgage or privilege recorded in book, and they give you the book number page, based on the loss or destruction of the paraffin note or release instrument. You see how when we start asking for it and they can't produce it, they have a backup instrument. This is how I found it on their websites, right? They have a backup instrument to request the courts release the debt.
Mm,
You see what I'm saying? This is another one. So this is
some
I'm not,
backdoor shit.
yeah, bro. I'm telling you, it's not a game. They really getting over, man. This is just sad that but it's addressable. That's the good news, y'all. Like it's not over. Like it's just there's some performance we got to do a little bit. It
So they
says
don't just get
affidavit.
to rape you and go home and shit.
Right. They know what they're doing, and then we don't know how to perform. And here's another one. It says affidavit of loss, promissory note, and authorization to cancel the mortgage. It's another that one. The other one was the note was lost. This one is the promissory note. So this is a request for I'm assuming it's the mortgage note, and this one is the promissory note. So there's so many different ways to come at their stuff.
Right.
They just messed up. They messed
No,
up,
it's the
man.
same.
They messed up.
No, bro, it's the same. They both the same. A note, they just dropped the word promissory, but it's still a promissory note.
Okay, so it
It's the
says
Yeah, a
same
note
thing.
is all.
Mhm.
Yeah, it's
deed
a note
though.
is a note.
It says
But
this one.
Oh, this says D.
Yeah, I was reading the
No,
top
if
part
it
of this
says
one.
D, you write it's a mortgage deed.
There you go. Okay.
Oh, that's different.
Hmm.
Copy. Yeah, I just read this. I was reading the front part of the promissory note one, and this one is the mortgage one. They're both
Oh,
like lost
Hmm.
parafeed or whatever.
Hmm.
Paraf.
tariff.
I got to paraf. Like paragraphed without the G or something. It's like parafed. I think that's it.
Oh,
Hmm.
Yeah,
Probably mean
all this stuff
lies.
in there. All this stuff is in there, y'all. I'm gonna put this in the mortgage group.
It's some deep stuff though.
It is.
Do you know that under Title 12, 266.39, a servicer does not have the rights of a holder in due course, which we are the due course, and therefore they do not have the right to collect the debt or foreclose? That's under the true title, Regulation
What?
Z.
You said 12,
1220,
266?
1226.39, Regulation Z, Part A. It's the first article, and that literally states a servicer does not have the rights of a holder in due course, and therefore they do not have a right to collect a debt or foreclose. And it says you've been hereby given notice that any attempt to collect a debt or foreclose on my property will be construed as prima facie evidence that you are committing fraud. And then it showed a couple recent case law studies.
Beautiful. I
I
like it.
have that wrong, evidently. You saying CFR 12,
It's
26?
12226.39, and it has quotes Regulation Z Part A next to it.
Okay,
I
thank you.
don't know if that helped. I
Hmm.
just saw that. I just saw that.
Oh yeah, I was going over Title 12 not too long ago. Title 12, yeah.
Yeah, very strong. And also the other one that's really strong is the Article 3-501B, which is the entitled to the demand presentation of the negotiable instrument, and that is for your original wet ink signature promissory note. And they will never, ever, ever be able to produce that, guys. As I was telling Mad the other day in the live, I found out through my audit that there's a company in New Zealand where it's like the Federal Reserve of mortgages, and they hold all the original notes. They only take originals. So every time that any mortgage company says, "Oh yeah, this is the original," it's a counterfeit, and you can prove it now, because if you need to
What's
prove
the
it,
I'm sorry, what's the number again?
the article number for the wedding signature is the UCC Article 3-3-501B. And that talks about the entitlement of getting that original wet ink signature promissory note, which they never can produce. It also shows about the allonge, and it has the claim to the holder in due course statement in there as well. I'm just showing you a couple ones that I have in one of my letters that I think this is the one of the this is one of the good faith validation proof of claim letters that was sent out to the mortgage company in the past. It also talks about the REMIC. I mean, they weren't able to produce none of this stuff. I just can't wait to close it out. I'm not losing my voice. I've been on the live all day with you guys on 3 different lives. This has been pretty intense day.
Yes, it has.
But I
Listen,
learned a
all of
lot
it.
of great stuff, and I really want to thank you all for, this is also, it shows you true. Like, this is our livelihood. This is not something we jump on and play with for an hour and okay, we're done and take some notes. Okay,
Right.
like we live this day and night and breathe it, and that's the real, and actually execute it, more importantly.
Right. That's the way. Enforce it, honorably,
Yeah,
non-belligerently,
and learning it.
non-combatively, like let them know and represent yourself. That's the most important part because they have you by the balls with that
Look,
signature. Until you address
the
that, they're gonna keep assuming that until you express that contract again, you got to do that. If not, they're just gonna railroad you. And if there's no power of attorney, and always look at their departmental procedures for you to insert a power of attorney. They might have their own regulations to kind of like protect themselves against these type of things. So always go to their website and maybe research what their procedures are, and then implement it. But once the power of attorney is on there, you are conveying whatever through the power of attorney, and they are liable for all the fees that come associated with that for non-compliance, duress, forced hire. Of course, we didn't even get into the heavy hitters, and that's when we realized, because they're acquiescence, you basically admitted that you you in the securities fraud. You know what I'm saying? Like you got some stuff going on there. I don't need to allege it. You just confessed it. You know what I mean? You just basically just let it go. So just always be able to invoice them. That's why I like when you have a power of attorney, if you have a trust, you can invoice them, and it's a lot simpler than the debtor saying send me a check. Or invoicing is definitely something that can be done electronically. You can email it, attach your stuff to it, the affidavits, and then you can do a 1099, forgive the debt on them. You see what I'm saying? There's all kind of things you can do.
pretty much like you said about what 100K said is no controversy, all facts.
That's it. No controversy, just a charging instrument.
That's
That's
it.
we here doing commerce. That's it.
It's very hard for them to argue that because everybody's usually coming with controversy, and I learned that these last couple months of going through the process because that's how I started with them at controversy, and now I'm going all facts. I stacked it all up,
Mhm.
and now I'm about to close it out properly. Done.
There we go here. A quick claim and assignment of beneficial interest is a legal document used to transfer both the title to a property and the best beneficial interest in a mortgage or trust deed. It is essentially a 2-in-1 deal combining two separate documents into one.
Okay, so I used that. No. Did I? Yeah, quick claim deed, but you can transfer or you can sell. So I sold. Does it matter?
You sold it to the trust?
Yes.
Okay.
Potentially.
So you just got that? Did you put that quick claim deed on file by chance? On record?
I'm making sure between you and Mad and doing some reading, I'm doing right, and I'm file everything. But
Yeah,
do I need to?
don't put that on file. Wait, I'm gonna let you listen to this real quick. You guys hear this real
Your
quick.
house to the trust when you have a mortgage on it. People ask me this all the time. How do you do it? Well, the way that we do it is we do a quick claim deed and we don't record it. In this country, it is legal to do a quick claim deed, and I can actually legally sell my property to the trust, but I do not have to go down and record it. So in America, we can use a quick claim deed to actually legitimately sell a property to the trust without having to go record it. The reason you don't want to go record it, you do not want to trigger the due on sale clause. So if someone was to sue you or take you to court and you were to show up with your trust document and your trust book, and you were to show that quick claim deed and that was a legal sale at the time, that property is not up for grabs, folks. That is a legal sale. I do not have to go finance the property in the name of the trust in order for the trust to actually own that property.
Thank you.
You're welcome.
That's some good jewel.
There you go.
Ain't it, sis?
So
Mhm.
that's my guy Josh from
Mhm.
Intelligent Banker, correct?
I'm not sure who he is, bro. Somebody
Yeah,
said it.
I know him personally. He's a very smart guy and he does the trust. He charges a lot of money, but he
Mhm.
deals with a lot of the big players and he sets them up on that. Remember that long name I told you? That's where I learned that from. That whole thing about the spendthrift trust. And he said that each of those words that are in the trust have a specific mechanism that I
Right.
think was the
They
word he
do.
used.
They do. They actually do.
So that's the same for the warranty deed. I'm glad I heard that. I'm not gonna go
Yeah.
change the warranty deed. Okay.
Yeah. Somebody said do a general warranty deed, and that's what I was just reading off just now was the where was it at? Oh man, I just had it. Well, I was reading off that beneficial interest, I think it was, that assignment. Yeah, that quit claim deed. Shit. Now I lost the guys. But that's what I think that is better than, the
A
quit
warranty
claim
deed.
deed by itself, right? Or the warranty deed. I mean, I know that the quit claim deed is you can stand on that. So I'm with that. I've seen it work, but the that general warranty deed, I just don't know it to even give any advice on that. So
I mean, it works, but when you go down there and alter it and file it, you got some smoke coming behind it. They're gonna be pissed off. I was just willing to take the smoke.
Yeah, that's
Thank
why he
you.
said don't do that because it can trigger the do not sell clause.
You right.
He said don't record it. Just bring your trust documents in any case.
Could you repeat that Article 3 code, please, for the people in the chat? What was it? UCC Article 3, I think.
Who was that? Who was talking? Was it Chef?
I think so. It was.
Yeah, it's Chef Jay. Let me pull it up here for you guys. Hang on one second. I put it away. I got it here. I got so many files. That is the letter with the wedding signature. You wanted that UCC 3.
It's in the chat.
You got it?
All right. Thank you.
It's Article 33501. I think it was actually B number 2 number 1 is what it actually has it in the little commas, if that helps. But it's Article 3-3-501. And it just talks about the wedding signature for the promissory note.
All right, here goes one for y'all. Negotiation of lost instrument or that obtained by unlawful means. When a negotiable instrument has been lost or has been obtained from a maker, acceptor, or holder by means of fraud or for an unlawful act, no possessor or endorsee is entitled to receive the amount due thereon from such maker, acceptor, or holder from any party prior to such holder. He cannot do so unless such possessor or endorsee is or some person through whom he claims was a holder in due course. Negotiation of lost instrument that was obtained by unlawful means. Come on, let's drop the mic stuff there, though. This one right here. We go. Let me see. I got some more in here too. Like these are things that people have gotten like remedy with. Like I leave it in there because when I see them shaking in their boots because of it, I say, well, that's perfect. We'll just let that go in there, and all people have to do is just get this power of attorney or this trust established to, convey whatever you're doing with these departments. And that is imperative. Like you really are going to be looked at as a debtor or somebody crazy because you're not addressing the contract. And if you, even have to have a copy of the contract, if you do have one, terrific. Now start addressing this stuff that you failed to tell me this part in here. You failed to tell me this part in here. You failed to tell me that this was going to be assigned on this side, that you even used the back of the document. You see what I'm saying? So once you convey this to them, immediately they know that they sold it. They think that they did something legal, but to me, it seems shifty as hell. Like that's
A truth. This is a very strong piece to put in the letters that I've always found helpful. It says claiming to be the holder in due course as a statement is insufficient proof of status and it will be rejected. A photocopy of the documents is insufficient proof as it does not answer the question who is currently the rightful and lawful holder in due course. When I was asking those questions, you got to tell them that they cannot a photocopy, because that again, they will not be able to produce. Remember that original document, when you sign it and it goes off, we all thought it gets maybe shredded or it goes to that company in New Zealand, and that's where it's
Mhm.
held. And that way they can never produce that ever. And and the photocopy, it's just more proof again for your records. It's just more stuff for your bullets in your gun, really.
Yeah, if you could send me that, I can add it to whatever we got in there.
I gladly will.
Thanks.
Could you put you want to I get your info from Matt, and I'll send you a little email with everything, okay?
Okay, cool. I appreciate you, definitely.
Okay,
Thank you.
thank you.
You ain't
Thank you,
in the
Matt.
Telegram like everybody should be coming and going through
No,
the
could you tell
Telegram. I
me the
don't get it.
Telegram? I'm gonna jump on it tomorrow.
All right, cool. Yeah, it's just Truth Hurts. It's right there on the website, and you just seamlessly just jump in there.
Truth Hurts with a Z, right?
Yeah, yep.
Okay,
Two eyes to see the lies. You know what I'm saying? You see that
yeah,
two.
I'm gonna jump in for sure. And yeah, I got some good gems here for you guys I can share for sure.
We definitely looking for those every day, all day.
And there's another thing. This is in your letter of debt. I mean, your debt validation. You make sure you put in there. Please also stipulate for the record whether or not my loan has been securitized, and if so, what's the name of the REMIC/trust my loan is bundled with. You ask them that. That's a punch to the gut.
Yeah, buddy, I like that. That's my kind of thought. I like that kind of stuff.
I
Right
knew you'd
there.
like. I'll put that all in the email for you.
Appreciate you, man. That's gonna go. We're gonna.
Repeat that
That's like
again, Chef.
injecting some of our affidavits already. You just put that, insert that in there. Now you got a Superman.
Well,
You know
yeah.
what I mean?
What'd you say? I'm
Right.
sorry.
Repeat that again for me. What'd you say? No, I just wanted you to say that again about
So
the
one
REMIC
of
or
the
something
things.
because my phone cut off.
One other things, if you're doing a debt validation as one of your points, put in there to also please stipulate for the record whether or not my loan has been securitized. And if so, because we know it has been, if so, please name the name of the REMIC, REMIC/trust that my loan is bundled with. Man, when you ask them that, they're going to be like, how the hell did he even know